Hello and welcome to the live event of our Leon County Family Law Clinic. My name is Colleen Mullen. I'm from Legal Services of North Florida, and I'm joined today by Christine Thurman of the Thurman Law Firm and Ken Kent from the Leon County Clerk of Courts office. And making sure everyone who's trying to join us is in. So anyone who's not presenting, please turn your videos off, because that way you won't be presented to the live audience. And so with that being said, let me say again, I'm Colleen Mullen. I'm from Legal Services of North Florida, and we're super thrilled to have Christine Thurman of the Thurman Law Firm, which is a very prestigious family law firm in town, and Ken Kent of the Leon County Clerk's office, here to talk to everyone about family law issues tonight. And with that, I'm going to let Christine go ahead and take it away. But if anybody has any questions, please feel free to put them in the chat. That should be at the bottom of your screen, and let us know any questions that you have as we go along.
Well, thanks, Colleen, so much. It's always an honor to work with Legal Services. You guys do such a wonderful service in the community and all over the circuit, as a matter of fact, in so many areas. So thanks for having me tonight. I know we had discussed briefly what to talk about, and there are so many areas about family law that impact so many people, like divorce and paternity, child support, parenting plans these days. And then you go into the larger issues at times that kind of multi areas. So tonight I'm here to talk about family law and the changes that we're seeing. I know we have a couple people that have joined. And so if you guys have any questions and you want me to start on any specific topic right now, immediately post it in the chat, because I want to make this beneficial for our joiners and anybody else out there in our live feed. So first I'll talk about family law generally, what's going on and what we're seeing, at least in our circuit. So Chapter 63 is our adoption statute involving all the adoption topics. And then Chapter 61 is our family law cases. And then we have Chapter 742, which is our paternity statute. And then 741 is our domestic violence statute. So those are the three that we deal with the most in the family law area. Most of the public is likely going to deal with Chapter 61 or Chapter 742, which is divorce, time sharing, custody, child support, which is Chapter 61, and then 742 being our paternity statute, which deals with children who are born outside of wedlock or not to parties that are married. What we're seeing lately, we're seeing an uptick in cases for sure, at least that's what I'm hearing from my colleagues. We are still doing a lot of Zoom trials and Zoom hearings. We have not had any live hearings, so our cases are moving slower than they historically have. But our judges are working so hard, and we are seeing judges setting hearings and being just as accommodating as they have ever been, which we have a wonderful set of judges in our Second Circuit. They work really hard, and our chief judge in family law, being Dawn Cloca Johnson, has been she has been amazing during this process in the last year by reaching out to all the attorneys, asking for our input, how to make things smoother right now, how to make things more accommodating for the general public. So just know, as much as everybody's being impacted by COVID and the changes, our judges and judiciary, our clerk's office, and all of our court officers have worked so hard to meet the needs that as we recognize them, and try to continue to keep our cases moving. But they're not moving quickly, but that's where we are. So talking about family law, most of the public is impacted by this topic because it affects so many people, whether that's your friends, your family, your own children, your own personal inner circle. Family law has evolved over the years, meaning we used to not have forms online. You had to go meet with a lawyer. You had to find out resources from friends and family. But now there is so much information that's on the web At the clerk's office, each of the clerk's office in our circuit, if you look up the county in which you live in, just going to the clerk's office, you often can find the forms directory for family law. There's also a statewide family law link at the flcourts.org, which is at the Supreme Court. You can immediately go to that page. You can click on the self-help family law section, and it breaks it down by topic. So finding information out there about family law, the forms you need, is so much more accessible and so much easier than it has been even in past years. I know that Department of Revenue's child support guidelines is out there floating around, but if there's anybody out there that needs the updated 2021 child support guidelines, I'm happy to provide that to anybody. That's an Excel spreadsheet that automatically plugs in our child support numbers, so we can easily, I'd say, working with a similar program across the judge's office and the magistrate's office to Department of Revenue and the practitioners in our area. It also helps to cut down discrepancy in tax numbers, because that's been a problem in the past between some child support guidelines programs. So we're all generally using Department of Revenue, their guideline sheet for child support. And then other forms that you can find if you're looking for, most of the law firms now will easily print out forms for you, or legal services. You can go to legal services, whether at their office or in the clerk's office, you can go get a packet of these family law forms. All of the Florida Supreme Court forms have specific instructions on them about what steps to take if you have questions. And of course, if there's ever a situation where you feel like you need legal assistance, there's multiple ways to find that in our community as well. Besides private attorneys, you can always contact legal services, legal aid, and then of course at the courthouse, again, there's a self-help resource center where you can go obtain additional forms if you need them. So that's the accessibility and the forms and where we are at the courthouse. But if anybody has any specific questions, I don't see anything in the chat as of now. All right, so divorce, where we are and what we saw this year in the legislature. We'll talk about that just briefly because we are seeing changes, or we saw some proposed bills in the House and the Senate this year, both on alimony as well as time sharing. Both of those bills did not pass. They both terminated while they were in committee hearings, but I do think it's important to note that the alimony bills, this is the second time in which we saw major bills be proposed in both. The alimony reform bill did pass in the past, but it was vetoed by then Governor Rick Scott. That bill, when Rick Scott vetoed it, had a 50-50 time sharing requirement as well as a retroactivity requirement for readdressing cases in alimony. Interestingly, this year in 2021, the same 50-50 is tied going up with these bills. So we are continuing to see that there is a large amount of support for readdressing alimony. I think that will be coming back. And then 50-50, which is statutorily not the case right now. The statute 61 does not indicate any presumption in favor of any specific time sharing plan, but I can tell you in our circuit, Second Circuit, we are absolutely seeing a presumption of 50-50 as a starting point. I think we have fantastic judges that listen to the facts and they do modify that if they find it to be appropriate. But from an overall family law perspective right now, we are seeing a vast majority of cases in the 50-50 realm, and that's from infancy all the way to 18. So we're seeing that be the trend in our area substantially. We haven't seen any major changes in any of the family law area other than those two bills. I know that there's always talk that we're going to see some modifications in some specific areas, but those two, meaning our time sharing and alimony, seem to be the ones that are the hot topics. And I think we're going to continue to see those bills be revived again for 2021 and 2022. Check-in, no questions. So, all right, so family law, where do we start? Most cases under a petition for dissolution, if we're looking at general dissolution, we're looking at a petition and an acceptance of service. We did have a modification this past year of the mandatory disclosure requirement. So in all family law cases where you're going to be addressing child support, whether that's paternity, child support, or in family law, being a divorce case, there is a requirement of mandatory disclosure. That's 12.285. That is where the court has laid out all of the financial documents that are necessary for family law cases that have to be exchanged. We saw a modification in 2021 that added some new requirements to that. So for the first time, we have a credit report requirement, which is a fantastic idea. I'm not sure why that wasn't there before, but it's there now. We also had modifications and extensions to the amount of bank statements, retirement statements that are required to be given now. It's beyond the 3-month requirement we've had in the past. And we also have a Bitcoin and cryptocurrency requirement. We have not had that in the past. So it's clearly the courts trying to stay in touch with what we see as changes in society as they apply to at least family law cases, which is identifying what the assets are and the value of those assets for the court to be able to divide those if the parties can't agree. So mandatory disclosure, that changed this year. We still see, after you do your petition and your acceptance of service and you work to get your mandatory disclosure exchanged, we still have our mediation requirement, at least in our circuit, and I think most circuits throughout Florida. Mediation being alternative dispute resolution. These mediations are being held via Zoom. And as a mediator and as a practitioner, I still think that in-person mediations are more beneficial and more effective, but this is where we are. So I know that Courthouse Mediation Services worked really hard on staying on track and keeping those scheduled, but mediation is a wonderful service, especially for many cases. There are very few cases that end up going to trial because parties generally can agree what their assets and debts are for the most part. So when you go to mediation, when you have a mediator who's trained in the areas to identify what the issues are and to really parse out what the differences are, we have a very high success rate on resolving cases before trial. Trial can be expensive. It's emotionally tolling. They take a long time to get to trial, and you lose control of the facts and often the outcome of your case once you put it into a judge's hands. So mediation still being a requirement in our circuit and an effective way to address the issues in most cases. If mediation isn't successful, of course, your case is going to go up to your assigned judges. In Leon County, we have 4 right now. We've got 2 new judges, Judge Hawks, Judge Baker Carver, we've got Judge Hobbs, and of course, our Chief Judge, Don Caloca Johnson. I would say that most of the judges are still scheduling final hearings 3 to 4 months from now, just depending on the time needed. Those schedules kind of change depending on how much time you need and the true issues in the case. But we're still seeing about 120 days as our trial scheduling dates. I think Don Caloca Johnson's is much further out because of her joint assignment being from Jefferson and in Leon County. So that's where we are in trials. 742 paternity cases often go on a similar path as family law cases. When you file your petition for paternity, you serve the other side with a summons with your petition for paternity. You have the same requirements to do your 12285 mandatory disclosure exchange. Those cases also go to mediation and address issues different than divorce. Of course, in paternity cases, we're identifying parentage, we're determining a parenting plan. Often we're doing child support, health insurance, and more specific parenting issues, and then attorney's fees as they apply in those cases. So they often follow the same path as a family law case, although the issues are streamlined a little different. And then, we've got domestic violence cases, which is a whole different path. I know we weren't going to go on the domestic violence path tonight, but still no questions. So Colleen, how much more you want me to keep talking about family law?
We do have a question in the chat. The question is, are there negative consequences on not filing a marital settlement agreement?
Okay, so this is oh goodness, hold on just a second. There we go. Interesting question, because collaborative law that has been codified in the last couple of years is a viable way to address resolution of issues. And I'm a collaborative trained attorney. Let me say that I think it's the most effective way right now to resolve family law cases. We do not file marital settlement agreements. We often also do not file financial affidavits by statute under the collaborative process. In a general non-collaborative case, there are considerations for filing and not filing. Filing the case, often the court has a record of the document. You're going to get a final judgment that approves that document, whether you file it or not. But there is always questions about marital settlement agreements and the amount of information that's contained within. Is it appropriate from a public information? Meaning, if you file it, one, we attempt to reduce as much identifying information as to your child, as to your finances, as are required by the rules of judicial administration. But you also have to think that there are people and creditors that are nosy. And nosy could mean that they just want to know what you had and what you just divided up. Child support guidelines are also filed, often attached to your marital settlement agreement, that addresses what your income is, what your child's expenses are, what your deductions are. So there's a lot of information in marital settlement agreements that go just beyond often your parenting plan. So it's a consideration of the parties whether or not they believe in their case it's appropriate. I would say that most practitioners in our circuit are going to recommend filing that marital settlement agreement because of the enforceability of the contract if something isn't followed. Most contain enforcement provisions that indicate if one of the parties doesn't follow the requirements, then the court's going to have to come in and enforce. Well, if the contract's already been previously filed with the court, you're just going to reference that in your motion to enforce. But if it hasn't been filed, then subsequently you're going to have to file that agreement with the court as you attach your motion to enforce. So does it keep people kind of on notice? Yes, it keeps people on notice that the court has the document. You can enforce it if you need to. But I still say, in the world where everybody can get more information than we're often comfortable giving, give strong considerations to whether you should or shouldn't file it, and talk to your lawyer about the concerns that you have and why you may not want to file that. Again, because collaborative is such a large practice now in our area, we are doing less and less filings just for privacy protection. And I do want to talk about collaborative because I think it's an area that's not getting enough publicity, especially with the amount of filings we have with the court and the court's limited resources on time, meaning our judges only have so many hours in a day for long period, weeks and weeks and weeks. They try to block out time for preparation. There's only so much hearing time that they can have. Collaborative law allows the parties to, in essence, resolve a dispute, often a divorce, by contract, again, codified by the legislature. So we still file a petition for dissolution, we get a case number, but we don't file any of the middle documents that we've historically filed, which the certificate of mandatory, financial affidavits, discovery documents that don't often happen in collaborative because it's a different process. Collaborative is a process where both parties have a lawyer. They have to be collaboratively trained. You have a financial neutral, which is often a CPA that's done the collaborative training. And then you have a mental health professional. You often don't get mental health professionals in divorce cases unless you're hiring a parenting evaluator. The wonderful part of collaborative law is you have most of which are either LCSWs, MSWs, or you have PhDs in our area. We have multiples that are trained to sit and meet with the parties to address the emotional issues tied to divorce, which in my 17 going on 18 years of practice, most divorces aren't truly about dividing assets and debts. It is dealing with the emotional separation of the parties. And so if you can identify what those true issues are, you save a lot of money much earlier in the process. And if you have somebody that's sitting at a meeting around a round table or square table, some of us have square tables, But if you have a mental health professional working with the parties and the lawyers to immediately identify what the emotional issues are, that mental health professional can meet with the parties without the lawyers. So you're cutting out the attorney's fees, identifying the true issues, and whether that is a mental health issue with one of the parties, whether that is substance abuse, whether we have a child that's got some academic deficiencies, whether we have parents that just fundamentally parent differently. We address those issues with a mental health professional and come up with a parenting plan. There is never an involvement of the court, except for issuing the final judgment. We can come back and modify over time. There's a lesser need for attorney-client privilege because in collaborative, the idea is to immediately identify the issues, work on meetings set over time, 30 days, 45 days at a time, set the agendas, and then working around the table when we say collaboratively to try to resolve those issues. It is a healthier way to resolve cases because kids aren't brought into the process from an adversarial perspective. If a child's brought into the case, we know that they're meeting with the mental health professional to truly address what their needs are. And their voices are heard differently than in a case where they're meeting with the judge behind a closed door, and we often don't even know the questions that are asked. So there is a Capital Collaborative group in the Tallahassee area. I think we have 11 lawyers now that are certified trained. I think we've got 6 or 7 mental health professionals. We've got 3 financial neutrals now that have done the training. And I think we've got 3 in the wings right now that are in the process of doing their training. The collaborative model has been used throughout the country for years. And we were one of the last groups that have formed, because if you look all over the state, there's large groups of collaborative lawyers. Where attorneys do nothing but practice collaborative law. And again, if I can tell most people to do some research on collaborative, most, if not all of the major players in our area, practitioners, are doing collaborative. They've done the training, they recognize it's better for the lawyers, it's better for the parties, it's better for the children in the process. And most of the time, but not all, it is much less expensive because you're not double hiring experts like appraisers or an accountant if we need a number done, or again, if we need evaluations done of the child, we're agreeing in advance who are doing those. So something to consider if you are seriously thinking about, going through a process that involves our family courts. Collaborative can handle any type of dispute that are involved. Paternity cases, domestic violence, believe it or not, although I haven't handled any of those yet, but especially divorce, modification cases where you need to go back and address either time sharing or child support, they're handled all the same. So I would advise everybody to kind of do their research. Capital Collaborative Group has a website, ccg.org. Go, all the bios of all the lawyers that are involved are there. And then you also can see the mental health professionals that are involved and the financial neutrals who are helping out in these processes. So we're really blessed in our area to have lawyers who are truly invested in best interest. And I think that the more that cases we see, the more cases that work collaboratively, it's just that the benefits are exponential because you can come back to the process over and over. Now, the one downside of collaborative, if there is any, in my opinion, is the statute requires that if either of the parties start a collaborative case and decide that they don't want to go collaborative anymore, they notify their lawyers, and both lawyers have to withdraw, and the parties have to get new lawyers. So they can't take the evidence that we've gained in the collaborative process. They cannot use much of the work product we've done. They have to start all over. So that is the incentive to stay in the process. But I've been trained in collaborative since 2010. I think that the more publicity we can give and more information and resources people know that they do have an alternative way to address their family law cases, the better we are as a community, because as wonderful as our judges are, we understand that the caseloads that they have right now, 1,000 cases, 1,500 cases for some of them. And I know especially our magistrates, where the magistrates are handling family law cases, many of those do not have attorneys representing the litigants. their caseloads are double our circuit judges. So anything we can do to provide resources and solve disputes without having to involve them, then I think we're all better off, because fast resolution to family law cases are better for everybody. So
we do actually have a question from social media. Someone asked, how long do you have to change your name back to your maiden name after a divorce is finalized?
Okay, so 2 ways to do name change. You can do it in your final judgment. So once you go through your divorce, your final decree, final judgment that officially divorces you, you can include it there. And if you don't include it there, you are going through a formal name change through the clerk's office at some point down the road. So you have to make that decision before the judge enters the final judgment as a name change. I tell my clients, if you think that you want a name change, make that decision before your final judgment, because it's much more than just a name change. You still have to go back and redo your driver's license and passport and social security and notify all your providers of the name change. So if you're going to do it, at least save yourself that $400 filing fee with the clerk. Get it done at the same time that we do your final judgment. And then you can decide how long you want to take to notify all of these providers of your change, but save the money. There's no ability to do a look back period. So after that final judgment vests, the clerk's office stamps that judgment, your opportunity is lost to go back and change your name, at least as to the case. You can do it separately, and that's to pay the fee for a separate name change. Of course, if you're going to consider a name change, you have to look at and the court's going to ask, have you been adjudicated guilty of a felony? Or are you attempting to change your name to avoid creditors? So if you're going through a bankruptcy, if you've recently had a lawsuit about any judgment claims or amounts owed, or if you've ever been adjudicated guilty of a felony, you cannot change your name. So those are the statutory requirements for that.
That's great. Sorry, I was having a momentary glitch of unmuting myself. Well, I'd actually like to ask Ken if he could go ahead and unmute himself, and he can give a brief overview of what the Leon County Clerk's Office can do for people, for the general public, and what kind of family law forms are available on their website, all those kinds of fun things. So thank you, Ken, from the Clerk's Office.
Well, thank you, Colleen, and I want to thank Christine. You did a tremendous job of describing where the forms are, what type of forms are available. So I'll just repeat that a little bit. You can go to 2 places, as Christine mentioned. You can go to the Leon County Clerk's Office at www.leonclerk.com, or just Google Leon County Clerk. Click on the Forms button and select the Family Law Forms. That will give you access to a series of forms, a series of packets of forms, and a number of questions about, for example, child support and other questions that you would have. And then, as Christine mentioned, if you go to floridacourts.org or just search on Google for Florida Supreme Court Family Law Forms, there are literally 5 pages of forms. Virtually every form that you could possibly need are available on the Supreme Court website. If you want to come to our office, we have really 3 services now available. One, for general information, you can come to our health center. That's currently a very small operation because our office is closed, but our office is opening next week. And so the health center will be open. You can go in, you can get copies of forms. You can, if you have a case, you can look up your case information. You can get copies of your case information as well. You can also, if you want to register for our secure website, you can get access to your family law case online as well. And so if you want to give us a call, we'd be delighted to walk you through the process. You basically need to go to the clerk's website, click on the secure web registration link, fill it out, get it notarized or have it signed by a deputy clerk at the clerk's office, and then we will send you a login and a password, and you'll be able to access your case and see things as they are placed on the progress docket. The other options that are available to you, we have recently opened what we call a low bono center, and that is available to anybody. It's in blocks of 15 minutes for $15 or 30 minutes for $30, up to 60 minutes for $60. And we have attorneys that are volunteering to assist in filling out forms. They cannot represent you in court, but they can give you general legal advice, and they can assist you in filling out forms that you would need for your case. Also, through our website, you can access what are called the Turbo Court family law forms. These have a fee of $10.40, but you can fill out basically a dissolution with children and a dissolution without children. So there's two different paths you can go down. You can select those forms. They will ask you a series of questions. And as you answer those questions, it will fill out the forms. You would then need to sign them. There are some other forms you would need to be aware of. So you could call our office or look those up online. You could bring them to the office and you could file that way. Now, of course, as Christine and Colleen mentioned, we always recommend, the one thing we can do as far as providing recommendations is recommend that anybody considering this should speak to an attorney. And we would highly recommend going to a lawyer. If you can't afford a lawyer, going to legal services in North Florida, legal aid, or using any of the other services that we briefly referenced. One final note, something that we see time and time again is that you've received your final judgment. We are required to record that final judgment. There is a $10.50 fee. It's required by the state of Florida Bureau of Vital Statistics. That is due when we record the final judgment. It often becomes a unhappy conversation with people. They're not expecting that. We may be adding that at some point in the future to the upfront filing fee, but we haven't done that yet. We just wanted to give people a heads up on that. But I think that pretty much covers what's available at the court's office. Christine, I do have a question for you that I hear from time to time from people, which is, as you know, this last year has been very turbulent and people have seen a lot of changes. If somebody has a change, particularly in their financial picture, what can they do as far as if they're paying child support, or what can they do to try and address that change? Maybe they've lost their job, maybe they're working at a new job that doesn't pay what the previous job did. And so how can they address that in the court process?
Okay, two ways to look at this. One, I would definitely say this is an area you definitely need to speak to a lawyer because this gets technical. If you have a temporary change in your circumstances, you can file a motion for a temporary abatement or temporary request for consideration. That does not permanently change your child support. That is going to modify it on a very temporary basis so that you can meet your obligation if the other parent is not agreeable to a temporary modification. But what the statutes say is we've got to look at, were you voluntarily or involuntarily terminated from your employment, because that has very different repercussions. So if you're working in a position, for example, let's say you had a position 40 hours a week and your employer said, we are not going to allow you to telecommute anymore. You must come back in, and you say, I'm not comfortable with that. I'm going to stay at home, and you lose your job. You are at that point involuntarily terminated. You have chosen that position or chosen that set of actions which causes you to lose your job. You do not get a child support reduction for taking actions in which you cause yourself to lose your position. And I say taking steps, not showing up to work, missing work, sick kids, unless you have one of the abilities to make a claim for protected action like family medical leave or something like that right now for illness. If you lose your job because of actions you take, you do not get a child support modification. Now, if you do lose your job, whether voluntarily or involuntarily, you have the duty to try to obtain employment at the same level that you were at before. the court is going to give you 1 year to do that. So if you are unemployed for 6 months, that is not a permanent change in your income. So again, you can file a motion with the court, ask for a reduction and indicate you're not sure it's permanent or not, but you want the court to take that into consideration. And I strongly suggest if you lose your job and you're receiving any form of benefits right now, whether that's unemployment benefits, whether that was PPP money if you're self-employed, you need to make steps to at least pay something to the best of your ability and be able to justify to the court what you paid and why. And if you can't pay anything, you need to look at the assets that you have, your savings account, your vehicle, your RV, camper, golf cart, all of these assets go into consideration of the court as to your ability to pay. It's not just your monthly income stream. But if you have lost your job, or for example, your company furloughed you, and you know that you have a 6-month or 8-month period where you're off, many of these individuals I know have been given benefits because a lot of this affects our clients. But again, you have to be able to come into the court and show that you've been without a job for 1 year is permanent. If it's less than a year, you're only on a temporary modification. You can petition either the family court for a child support modification, or many people use the Department of Revenue. I know that myflorida.com, you can go to Department of Revenue Child Support Assistance, click on that link, indicate that you want to get assistance with child support, and they review those cases on an administrative basis with a hearing officer if it goes that far. And they help determine, has there been a substantial change in circumstances? They look at the income. Again, child support only looks at the incomes of the parents, not the parent's spouse, not the parent's family members, not the other people around them and their lifestyle necessarily. So it's truly just the income of each of the parents. We are seeing some child support cases that modify because of health insurance changes. We've had a lot of health insurance cost changes. If your health insurance has modified on an annual basis more than 15% or so, which dramatically impacts your child support guidelines, which is, I say dramatically, which is $50. That used to be the statutory language, is $50 or 15%. If that's going to be your change, then to me, that warrants the court looking at it. So got to consider the job loss. What was the reason you lost it? How long you've lost it? And does it make sense to go back to court? Because often, even if you file that petition, there's going to be a substantial period in time until you get a hearing. The court has the ability to do a look back period to the date that you filed that petition. But one of my favorite judges, Judge Hobbs, she always tells me if we go into court, she's like, did that baby need shoes? Did that baby need groceries? So just because everybody's changing, these kids still have needs that don't stop just because of income. So I am a strong advocate of my clients really looking at their lifestyles. If they've changed jobs or had to transition employment where their salary has either been reduced for whatever reason, you need to look at your overall lifestyle. You need to look at the assets that you have. Do you truly have the ability to pay? Because your income is not the only basis to do a modification. And I've seen courts deny child support modifications when golf club memberships haven't changed, or spending on iTunes, or upgrades in other areas of your life have happened, so there's a lot of things to look at when we look at child support modifications over and beyond just income and employability.
Speaking of child support, another question we get a lot, and you touched on this, is the parties have a judgment. It specifies the amount of child support, but the non-custodial parent or the parent who's required to pay the child support isn't paying. What can the custodial parent do? What are their options?
This is a really tough area. And I will say this, kind of watching over the years, I differentiate cases on enforceability. And I say enforceability of a judgment. You must look at the non-paying parents. One, are they a W-2 employee? Or number two, are they self-employed? Or three, underemployed, meaning historically underemployed. So the court has a duty to impute minimum wage. And if that's been the case where you have somebody who the court has historically imputed minimum wage, whether or not they're working or not, there's always the concern that you are chasing somebody that rarely, if ever, will pay. If they are a W-2, if the non-paying parent is a W-2 employee, then I strongly recommend always go file a motion for enforcement, whether you do that on your own or with a lawyer. If there was an agreement for child support, like a marital settlement agreement, you've got an enforceability clause that's often going to provide attorney's fees. Use that clause as your get into court. You're going to pay for this one way or the other, and have the judge hold them in contempt. I think you have different results in the Department of Revenue hearing officer realm than you do often with the magistrate and circuit judges. Department of Revenue has tools for enforcement that we don't often have. For example, they have the ability to intercept tax returns. They have the ability to access tax transcripts, to suspend driver's license. That's CDL and standard. They have the ability, both courts do, but we see it used much more frequently in the administrative and hearing officer realm. If the parent, though, is a self-employed individual, and these are the areas that are the hardest for us to enforce. Often these employees work under the table or for cash. They do not deposit that cash into bank accounts. They hold no assets in their name, whether it's a vehicle, whether it's a house. You are often spending what I call good money after bad. You will get a judgment and you will chase them, and you will constantly try to enforce that. And to the extent it's very inequitable and unfair, I ask my clients, this is a cost benefit analysis, and the cost is not just the financial cost, it's the emotional toll of going in front of the court repeatedly asking for enforcement when often they don't show up and we're spending money trying to find and serve them. That is very difficult. However, I do think it's really important, if you have a parent that is going to habitually not pay and you need that help, whether it's health insurance, whether it's medical issues with a child, or whatever the reason, you must create a court record. You must file multiple motions for contempt and enforcement. You need to ask the court to issue a writ of bodily attachment or throw them in jail. Again, kids need to eat. They have expenses. Having a child is a two-party decision. But we don't see that remedy being used very often, which is the purge. And I know since COVID last year, nobody's getting arrested for not paying their child support, which is unfortunate because I think it's being used inappropriately right now. As a market's changed, I'm not working, kids aren't going to school, they have lesser need, you don't need this money the same. I still say, no, file your motion, show up in court, show that there's a pattern of this, and ask the court to hold them accountable. And that's men and women on this issue.
Couple of questions about custody, unless somebody's asked a question that we see from time to time. One is, how does one go about establishing custody?
Okay, so Ken, when you say this, I'm thinking when you say custody, you're talking about parents of a child, because we do have the issues with grandparent custody cases, and I'm seeing a spike in relative, non-relative placement cases right now, which are not coming through the DCF Chapter 39. So I presume we're talking about parents.
Correct, where the individual knows they're the parent of the child, they want to be involved in that child's life, and they're trying to get named as a parent so that they can participate. Okay,
so we're likely talking about a 742 paternity case, which is a child born outside of wedlock. Yeah. Because in the state of Florida, there is a presumption that if parties have a child, the mother is going to be the primary sole parent, even if the father is listed on the birth certificate. She is the sole parent making all decisions unless and until that father avails himself of the court system. And that can be done in a couple of ways. One, your putative father registry, if he's not on the birth certificate, filing that and do an acknowledgement of paternity, which is a form that you can file at the clerk's office, or with Vital Statistics in Jacksonville, that putative father registry needs to be filed. And then you need to file a petition for paternity. So acknowledging to the court that you are going to step up, meaning and assume a role in this child's life. Putting your name on the birth certificate creates an obligation to pay child support. It does not provide parental responsibility. So it's important for the father of the child to file a petition for paternity with the court, asking the court to award parental responsibility and to create a parenting plan. So filing that petition, telling the court what you want your parenting plan to be, and filling out your financial affidavit and the mandatory disclosures that are necessary is the first step to creating what I call parental responsibility and getting involved with the court on time sharing. So filing that and then seeking a hearing, getting a temporary hearing and walking into court and telling the court that you're prepared to parent your child, that you have appropriate housing, you have childcare available or lined up in the, to the extent when your time sharing begins, and also being prepared to pay child support, because part of that decision to go in front of the court system is acknowledging your responsibility, both financial and emotional, to the child. So taking those steps, meaning being involved with the Department of Revenue and having a child support obligation, does not give you shared parental responsibility in a time sharing plan. So making sure that everybody knows that unless the mother of the child is going to agree to the time sharing schedule that you want, the court's going to have to create that parenting plan and put that into writing, into a document that you have to enforce it if you need to. Department of Revenue in the last couple of years has expanded their role in cases where the parties do agree. The statute now allows them to incorporate that parenting plan into the final judgment for them under the administrative, but it's only if the parties agree on what that schedule is. If the parties aren't going to agree, it's required for the mom or the dad of the child to go in front of the circuit judge and petition the court and indicate that I've been adjudicated child support, but I want a parenting plan. So you've got to file that document, serve the other parent, take the steps you need to set a hearing and get in front of the judge to get a parenting plan laid out. And that parenting plan, once it's established, will not change until that child is 18, unless and until there's a substantial change in circumstances, which is a pretty high legal burden that you have to meet. So once you get that plan, make sure that's what you want, that's what you're going to exercise, and then carry that out until the child's 18.
I promise, one last question, and this is something we've seen, but I always hope never to see again. What would somebody do if the other parent takes the child out of the circuit?
Okay, so out of the circuit is different than across state lines. And with us living in Tallahassee, going to Thomasville being within 50 miles does not violate our relocation requirement. So can I think when you're saying this, you mean travel or you mean relocate?
Just they move, they come get the child, what the other parent assumes is a routine visit, and then they don't come back.
Okay. So if a parent has relocated, and when I say a parent, we are talking about where the parties have a parenting plan that's been filed with the court, and you have a final judgment saying you have this time and the other parent has this time. Neither party can move more than 50 miles. And I say 50 miles and as the crow flies, this is not on Google Maps, but 50 miles you can move without court approval. If you move more than 50 miles without court approval, the non-relocating parent can file an emergency pickup order, return of the child, and can seek sanctions. It is not allowable for anybody to move without court approval. And I say anybody, it's not the parent with primary custody. The statute reads either parent who has a time-sharing plan has to petition the court prior to moving. Does that always happen? No. But I can tell you it is often deemed as very unfavorable by the court for a parent to move without approval. And it often will backfire and negate any requests for moving or a change of custody by the court. There is also the same requirement, though, that you notify the other parent as soon as possible and try to get an agreement. If you have an agreement on relocation, if that can be reduced to writing, filed with the court, you don't have to go through all the formal steps that are required, but you can't just up and move. And you can't just up and travel with the child. Most parenting plans require notification in advance. And I'd say most of the marital settlement agreements or parenting plans that I deal with, there's a 3-day requirement if a parent's going to travel within the state of Florida. If you're going to leave the state or even the country, typically there's a 10-day or a 30-day notification, and the other parent has to agree to that travel before the child can be taken out of the jurisdiction. And then I know in Tallahassee, we can go, you can almost do the entire circuit, maybe with the exception of Franklin County, that you can move without court approval. But let me, a little tidbit of advice is, even if you relocate and you're within that 50 miles, if you make it impossible for the other parent to be able to get the child to school, you've got to look at that. And I've actually got a couple cases in front of the court right now is, what do we do about that? Like a move from Leon County just across the lines in Wakulla County, and it puts a child in Wakulla County schools, or Gadsden to Leon, Leon to Gadsden, Leon to Jefferson. So there are some considerations on moving, may have bigger impacts, even if it's allowable by the court. It may make your parenting plan unworkable. And then how should the court address those issues?
Thank you. So Colleen, are there any other questions?
I haven't seen any other questions. I'm going to give our social media just a minute. They're being telephoned to me. Okay, we don't have any questions on the social media. So it looks like, this has been a very successful informational clinic. I want to thank Christine Thurman and Ken Kent from the clerk's office. And if anyone has any questions, they can reach out to Legal Services of North Florida, to Christine at the Christine Thurman Law Firm. Or if you have a question that is regarding just the paperwork, you can always reach out to the clerk's office, and they'll be happy to redirect you if you're asking a question that they can't answer to. So with that, I'd like to thank everyone for coming, and I hope everyone has a very nice evening and a very good weekend.
Take care. Thanks, Colleen. Thanks, Ken.
Bye. Thank you,
you.
everyone.
See you later.
Bye-bye.